Senator Hunt, you're recognized.
Thank you, Madam President. I rise today in strong opposition to LB632, a bill that on its face is meant to be seen as healthcare regulation or about public safety. You know, Senator Hansen said public health, which when he said that, I would like to see the evidence that fetal tissue remains are more dangerous to the public health than fluoride. But it's important that we take time to be precise here. This bill is full of ambiguity. It contains really vague directives, undefined terms, unclear enforcement mechanisms, and if we want the law to work, that's a problem. And they aren't just technicalities, it's the foundation of what makes a law constitutional, enforceable, and fair. So what worries me about this bill is how it will actually work in practice. First, the issue of disposal. LB632 mandates that remains from an elective abortion must be cremated, buried, or otherwise disposed of per rules adopted by the Board of Health. But nowhere in the bill does it define what constitutes fetal remains. So it kind of begs the question, is this applicable to a 6-week gestation where there is no discernible fetal tissue at all? Is this meant to apply to a medication abortion that happens at home where a patient might not even return to the clinic? What about tissue that is sent to pathology, which is standard medical practice in many clinics and hospitals? You have to ask, will that require separate ceremonial handling? Will clinics need to contract to funeral homes? And the introducer talked about some of those questions, but the fact is, it doesn't matter what his opinion is on the record that he said. What matters is in the text of the bill. And the text of the bill is vague and unclear about that. And that means providers will be left guessing. When providers are unsure about what the law requires, one of two things happen. They either stop providing care altogether, or they overcomply in ways that are burdensome, that are expensive, that don't result in any better outcome for patients. And either outcome, colleagues, is bad policy. Either outcome leads to bad results for Nebraskans. My second concern, and I'll tap back in because I don't know if I'm going to finish my thoughts here, but the second concern is that this bill creates a new legal exposure for medical professionals. Section 4 of the bill allows any person to bring a civil action for failure to comply with the disposal requirements. So think about that. We're not just giving the right to sue, not just to a patient or to someone with standing, but to anyone. And that's a huge exposure for legal liability and one that would chill providers from doing even routine reproductive care. And this opens the door to harassment lawsuits from politically motivated individuals or organizations. And that's not a hypothetical. We've seen that strategy deployed in other states with abortion bounty laws and so-called whistleblower enforcement, and Nebraska should not follow that lead. Honestly, I think that's something that proponents of the bill are probably aware of and probably like about the bill. People call it a backdoor abortion ban, but I'm concerned it's also a backdoor abortion bounty law that will allow politically motivated actors to file these politically motivated lawsuits, which again, not only puts providers in danger, but really ends up targeting patients who just need to be left alone, who just need to recover from medical procedure and just need to move on with their lives. And then what about Section 5, where Attorney General can bring enforcement action and levy fines up to $2,500 per violation? Again, we have no guidance on what a violation even looks like. Does that require documentation, record keeping, a signed attestation from a patient? What happens if a patient doesn't want to participate, doesn't want this to happen to their remains? This section gives the Attorney General broad authority to enforce the law and levy fines up to $2,500 per violation. But nowhere in the bill does it say what a violation is. It doesn't say what kind of documentation a provider needs to keep, how long they need to keep it, or what kind of evidence the Attorney General must present to prove noncompliance. So there's no rules of the road here, there's just the threat of enforcement. And this feels like another bill where the introducer has an idea based on a flavor of morality, but the actual enforcement and implementation of the bill through the language is not workable. Thank you, Madam Chair.